Earlier we had discussed up to query number 4 of the circular. So we'll be starting with FAQ 5 of the circular. Now, FAQ 5 says whether the benefit under section 128 is available if the taxpayer intends to avail partial waiver of interest or penalty or both on certain issues by making part payment of the amount demanded in the notice, as the case may be, and opts to litigate for the remaining issues. So on a simpler side, and since we have all gone through the rules, it says that if waiver has to be opted for, then the entire amount of tax demanded in the notice or the statement or order has to be paid. So this is the simpliciter version which the circular has given. Now the question comes that what CGST is doing presently is that they are issuing a common order for section 73 and 74. So now, supposedly, if a taxpayer wants to opt for the waiver scheme under section 128A and there's a common order for section 73 and 74, then what is the option available with the taxpayer and how he opts? Because if we literally read this question number 5, then the simplicity answer would be that entire amount of tax, penalty, or interest, whatever is there in 74 has to be paid, and then only option can be availed in 73. But from my point of view, what is my understanding, and then I would open the question for the group as well, that the entire schema of the Act, if we see, there cannot be a common order for section 73 and 74. And the summary of the order, which has to be issued under Rule 142, it only allows the summary to be issued either in 73 or in 74. So even if there is a common order, there would be two summaries, one in 73 and second in 74. And since this is an online process and the law also not does not envisages a common order, so therefore a view comes that even if a taxpayer wants to opt for a amnesty scheme for a common order, he only needs to opt for section 73 and not for 74, and that section 74 can be litigated separately. Because if we are going to file an appeal also, if there are two issues, one for 73 and other for 74, then two appeals have to be filed because they are separate DRC 07. So if there are two appeals, one for 73 and second for 74, the 74 can be continued, and for 73, we can opt for the waiver scheme. This is one view which can be shared for this common order for 73, 74. Now open for the views of the members.
See, Arpitji, now the challenge that is that the waiver of interest and penalty is applicable only when the full amount is paid. Now, if the
Yes.
order has 73 and 74, and this scheme doesn't apply for 74, that means we are now making the payment only for the partial thing. So, somewhere either we are violating the circular provision or we are violating the intention of the scheme. Ideally, for the entire 73 demand, it is applicable. Now, I choose to pay for the entire 73 demand. Technically, the scheme should be applicable. The FAQ will become redundant because I am not paying full tax in the demand.
But hasn't the officer committed a wrong of in the statute by passing a common order? So why should I suffer for the wrong committed by the officer? Yes, the FAQ says that the entire amount has to be paid, but that is for 73 only, not for 74, because the wrong has been committed by the officer.
I agree. Maybe others, but I don't know how the portal would then be working because it would be looking for the settlement of the full DRC.
Yes, but there would be two DRC, one for 73 and the other for 74.
legally, this point is correct. They should actually abide by Rule 142, Sub Rule 1, Clause B, where the statement to be issued separately for Section 73 and 74 notices, right? So far as the law point is concerned, I go with the view of Haldiaji, and it is interesting to see that how modality works, okay, how functionality works. Regardless of this, this point is so clear to my understanding.
Because everyone would be having common orders for 73, 74 in CGST.
No, practically, I think we should approach the court with a prayer that the orders, wherever there is only one order, should be severed, that there and split into 73 and 74, and then make an application through 128A, and don't go directly to 128A and get a rejection.
Unikishan ji, wouldn't it be possible that we apply for 128 for the 73 only, let them reject and then go for appeal, because there is a provision for appeal for one rejection in 128A.
No.
On what ground we will go with to the High Court directly, right? There has to be a suffering first. So before having any order as such in our hand, how can we approach to the court saying that there is a suffering? Yes.
The multiple courts have taken cognizance of the bunching itself when multiple financial years were up together as a cause of action. So similarly, when 73 and 74 are bunched in a single proceeding, that itself is a cause of action, in my opinion.
That's okay. I thought if there are two DRCs with us, we do not have any way to go to High Court, right? That's what I was trying to say.
So let us, if there is if a single DRC1 or if there's a single DRC7 for the matter, where both 73 and 74 are being pushed into, that itself, I believe can be a cause of action to approach the court.
Yes, one of the DRC which we are having a similar matter wherein both 73 and 74 were issued. So what the officer did, he issued the entire DRC 07 and 73. Including the matter which was passed in the order in 74.
Yes, because that is how practically the CGST guys were doing.
Yes, any other views from the members? So,
I think we will move on.
So what we can conclude and what based on the discussion is that if there is a common order for section 73, 74, there could be two scenarios. One, wherein two separate DRC 07 have been uploaded, one for 73 and 74. So in that case, if the modality allows, because this is a one big question that how the modality would work. So if the modality allows, then 128A can be opted for 73, and it's a given case that a department would reject and ask for payment of the entire amount. So in that case, an appeal would have to be filed against the rejection. And if there's a common DRC 07 under section 73, then it becomes an interesting case. And in my opinion, a rectification application could be filed before the officer to issue separate DRC 0 for 74. Hello?
Yes.
A rectification application can be moved for issuing a separate DRC 07 for 74, and then the same process can be opted for.
Provided that we have a time limit under section 161, 3 months.
But it is a clerical error. It is not a error from the taxpayer side. It is a clerical error from the. So in that case, the time limit would not be an issue.
Actually, when we read 161, it says the period of 6 months shall not apply in the cases where rectification is purely in nature of correction of clerical or arithmetical error, right? And
Hmm.
this 6 months, the 6 months time limit is for the doing of rectification. And when you read the main body provision of section 161, that is providing a time limit of 3 months from the date of issuance of the order. Okay, so that second proviso to 161, which says that rectification, rectification time limit is 6 months. 6 months of rectification time is not applicable in a cases where there is a clerical error, right? So 6 months time is qua rectification. Okay. So far as application of rectification is concerned, that is the stagnant time limit regardless of anything.
But
You have to apply within 3 months. That is what the reading is. And they may
Yes.
make the rectification beyond 6 months in a case if it is a clerical error.
Point
I
taken.
disagree. I feel that 3 months, 6 months is from the wholly different perspectives. 3 is when you make an application, and 6 is when the officer wants to do without an interference from the taxpayer.
See, when we read 161, okay, first proviso to 161 says, provided that no rectification shall be done, okay, after a period of 6 months from the date of issue of such decision or order or notice or certificate or any other document. And then it says in second proviso that provided further that the said period of 6 months shall not apply in such cases where the rectification is purely in nature of correction. So this such 6 months, such period of 6 months. So of course that is relating to first proviso only and not to the main body provision of 160.
In that case, we can do one thing, that after expiry of 6 months, we can make a request letter to the officer to make the correction. So that can meet the purpose of what we are discussing.
Sir, one more question. See, 161, the body talks about two rectifications. One on its own motion, or two when the application is done by the taxpayer. So such
Yes.
rectification can apply for either one or two. So
Yes.
two, I agree, can be something where the application is the triggering factor. But one is on its own. So that can still extend to 6 months independently.
Yes,
Yes.
for own motion, there is no time limit. If we,
Yes.
I am
Yes.
sharing section 161.
Yes.
This is section 161.
Yes. And this own motion. Yes.
Either on its
So
own motion or where such error is brought by the
so,
to its notice by any officer or by the affected person within a period of 3 months. So period of
so
3 months application is apply wherein it is brought to the notice by an officer or by affected person within 3 months. But in for own motion there is no such time limit, and the order can be passed within 6 months, or in case it's a clerical or arithmetical error, then beyond 6 months also.
then
Yeah,
how would
I
you?
agree.
Then how would you? Because going by that way, that when we will request the officer, right, in writing, in that case it is the second option, it is not the first one, right? So how to make it effective so far as this first action is concerned, own motion?
The officer have to do it on his own motion.
Vivekji, the officer would be forced to do it on its own motion. They are doing, they are issuing it completely in the section under section 73. However, if they have issued under section 74, then there might be an issue.
Sorry, I could not get you.
See, in the common order for 73, 74, there can be two scenarios. Either the entire DRC 07 is issued under section 73, then in such case, he would have to do it on its own motion of issuing a separate DRC 07 for 74. But in case the entire DRC 07 has been issued under section 74, then there is an issue of period of time limit of 3 months.
See, there is one more scenario that needs to be discussed here. Let us assume that this practice, which was prevalent in the early days, was regarding an order for 1718. So 1718, they passed a common order for 73 and 74, depending on multiple paras. And I filed for an application, but they did not feel that it is a item that has to be rectified. And the order was undisturbed. To prevent limitation from setting in, I appealed against the original order on the grounds that first it is having an error of principle that there is a common order for both 73 and 74 as my primary ground of appeal, and also entered into other grounds of appeal. Now, in this case, the appeal is pending, or even there could be a scenario where the appellate authority has also disposed of the same, saying that no, that is okay, the parawise invocation is correct. Now, it is a stage of appeals where the appellate authority's order under 107 is the subject matter of 128A. In this case, what could be the solution when there is a common order for 73 and 74?
So again, if the matter is pending before the appellate authority, then the ground would be there. And then effort would have to be made that the order has to be passed by the appellate authority within the stipulated time period of the scheme. But if the order has been passed by the appellate authority, then again section 161 comes into play.
No, appellate authority cannot sever the order into two. He can only either uphold that there is a mistake in principle that the order cannot survive when it is invoked together, or confirm that there is no error and it has to be independently viable. So he cannot enter into a totally different thing and say that there can be two proceedings. He cannot create proceedings on its own from issue of show cause under separate proceedings and non-issuance of an order under separate proceedings. He can only decide upon whether that was correct or not. I hope I got my point across.
You got it. So if there was a specific ground of appeal for bunching of multiple issues for 73, 74 in common order, and if he has disposed of, then the only option left is writ before the High Court. If the ground was not there for separate bunching before the appellate authority, then in my opinion the issue is not yet decided, and it can still be we can still go to the officer under section 161 for issuing of separate DRC 07 or making a rectification of DRC.
The officer cannot entertain the original order or issue a rectification because he is a functions officio, and that order has already been subject matter of a decision by a higher authority. So he cannot touch on that original order again.
But if the ground was not there, was not there, and the appellate authority is not yet,
I think this view is also required. I think this view is also required to be tested, aligning with section 107 subsection 11, which says that appellate authority, after making such further inquiry as may be necessary, okay, this view is open to all. So I am also not very much clear on it. It says that the appellate authority shall, after making such further inquiry as may be necessary, pass such order as it thinks just and proper, confirming, modifying, or annulling the decision or order appealed against. Okay. So what is the scope of the word modifying? Okay. And they are not just saying the appellate authority shall pass an order. It is saying shall, after making such further inquiry as may be necessary. Okay. This phrase is
can modification result into a separate order itself when there is only one order in the first place, other than one that arises independently from 107.11, where a show cause notice is issued by the appellate authority and adjudicated for additional those four things: penalty under first proviso and the increase in demands under second proviso, and that too within the original time limits of 73 or 74 as the case may be.
So, Unikishan ji, do you want to say that the only supposedly I am in an appeal, and I have made a ground that
Hmm.
this order is invalid because 73 and 74 had been put in a common order.
Yes.
So the only option available with the appeal authority is to accept the appeal and reject the entire order.
No. That is if on the question of law whether a single proceeding can take care of both
Yes.
73 and 74. Alternatively, if he steps into 107.11, he can create something that is not part and parcel of the original proceedings. So 107.11 cannot be used for something that is not already there in the original proceedings. It has to be something he has found out for which he is issuing the show cause notice. And that too has to be independently within the limitation of 73. Which
Yes.
would have already expired by the time appeals are right
Yes.
now.
Yes.
So effectively, 107.11 proviso cannot result into severing of the original demand
Yes.
unless it's a 74 case, which has to be saved. But then no way, nobody's going to do that.
So in that case, the only option available with the appeal authority is to quash the entire order, saying for bunching of 73, 74, but that we know that he will not do so. The only option available with the taxpayer is that to approach the High Court once the appellate order has been issued.
That was what I was feeling that should be the case, because severing of an order has to be something that court has to interfere in. And even the adjudicating authority, even for the matter, in my this is a fresh view, but I don't think even a rectification can be done, because a rectification can be done for a mistake and to cure or remove one aspect, 73 or 74 from the original notice or proceedings. If once it is removed, then there has to be an entire new proceedings for the balance thing that ought to have not been bunched. So that will create a new proceeding altogether. So it cannot be a rectification of a mistake. Because it is a decision that he took that it is possible. It is not something that requires simple application of mind. Once he removes something as bunched erroneously, there has to be a separate proceedings totally.
No, can it not be a case that he issues two DRC-07, one for 73 and one for 74, and therein a common order is issued? Because
Again,
proceedings under GST are carried out through DRC-07. So if there are two DRC, but it's common order for both the DRCs.
I get it. As long as there are multiple DRC, this rule and the system will gel well and stick on. But the thing is, those are all very ancillary items we attach to and looking into from the technical side. Shouldn't there be an independent show cause notice which serves as a foundation on which that DRC1 or the order on which a DRC7 serves? So there has to be a separate adjudication process or a separate notice stemming from the very first start of that proceedings. Otherwise, if you simply rectify and simply issue a DRC1 or a DRC7 as the case may be, then there was never a proceedings to arrive at that. So there has to be, it has to start from the original inception. There has to be a show cause. There has to be another order.
But in many cases, there is no DRC-01.
Because initially then if it was an order, if you apply for rectification of the order, then that means that the original order is going to result in a new DRC7, which didn't have an independent show cause notice. The original show cause notice itself was on a flawed basis. So it didn't have an independent 73 notice from which it can stem into a adjudicating order purely on 73. No, again, just voicing my thoughts.
Hello.
I'm just thinking what could be the problems when we try to sever.
Hello.
Yes.
Hello. Sir,
Yes.
is it any, my two questions are there. Is it any way possible for an adjudicating authority to demote a SCN under 74 to 73?
No.
No. Now, if it is not there, then there cannot be a case that notice is issued under 74 and any order can be issued at adjudication stage under 73.
No,
that
is what I'm saying, sir. I agree. That is why we are talking about cases where para-wise invocation of 73 and 74 are present.
In the show cause notice itself.
Yes.
If it is, even if it is invoked para-wise, can it be invoked para-wise?
That is the subject matter of the appeal, which they won't enter into.
No, as per the law, whether it can be invoked in a single notice pairwise.
No.
Do we agree
In
on
my
this?
opinion, no.
No.
No, if we cannot start with the thing that is it an incurable defect in the show cause notice?
In my opinion, yes.
If it is incurable defect, can it be cured under 161?
In my opinion, no. That is why I feel 161 is not applicable.
Now, yes, 161 cannot cure an inherent fatality in the show cause notice. We agree on that.
I agree.
If it is so, whether I should go to 128 capital A or stick to that, it is incurable. Because in any case, it cannot be cured. In my humble opinion, can it be cured under any process of law when it is not initially good? It cannot be cured even. Then 120
Right.
capital A.
But in such case, if we fight on merit, ultimately the High Court would remand it back somewhere at some point of time. Some authority would remand it back, saying that a fresh proceeding shall be initiated, and by that time, 128A would already been gone.
It would happen if one takes route of 2 to 6 writ petition, but if the file is on record up to tribunal, can it in any way, because we will have to see whether we will vitiate entire first stage is mistake in the show cause notice, second stage is mistake in the at the process time of 161, and thirdly at the time of 128 capital A. 128 capital A will surely conclude the proceedings. Whether initial proceedings were good or bad, it will conclude. For example, notice was bad, order was bad, but proceedings are concluded. It is okay. But if this route is not taken and matter is kept in appeal, in my humble view, if the settled law is that 73 and 74 cannot be invoked in a single show cause notice, whether department will may in any case under 128 capital A, we get these proceedings concluded from my side. I am sitting at home. Thereafter, department initiates proceedings on any cause. Is it some? Do we look any issue for the assessee because he forgoes this right, and ultimately something happens of that kind? Because going to writ petition will surely move the proceedings to point one. Okay, issue two things beyond the time limits, that will not be in the interest of assessee. On the other side, if there is something so bad in the show cause notice itself, whether it will be prudent for 120 capital A. Second is whether what we have seen, it is not possible to issue rectification orders beyond 6 months of application. It is not possible, no? On
Yes.
161. And if it is not possible to issue any rectification order beyond 6 months, they can only reject the application, nothing else. First point. Second is if I might have took this from other point, whether on his own this rectification can be done for any point of time. There is no time limit for rectification on his own.
That is for arithmetical and clerical error.
For arithmetical and clerical error, an order can be rectified for any period.
Yes.
Okay. I think it after appeal, once appeal is filed, if it is for any period, it is not barred by 107 any other section.
So the question is that once that was one also point, that once an appeal has been finalized, then the original officer becomes functus officio. But for which issues? The issues which have been taken into appeal, or for all the issues which, even though they have not been made part of the grounds?
But for arithmetical errors,
But the doctrine of merger would apply once the appeal order has been passed.
Yeah,
So the
has been
individual
passed
order
until
would not be.
under appeal it will not be possible. If the matter is under appeal, even then this matter can be rectified. If new order has not been passed yet,
Yes.
until then matter can be it can be rectified. We say, no?
RPG,
Yes.
it's 9:30, just a reminder.
Yes, yes. Sir,
Okay, sir. These were my 2 issues in my mind.
no, very true, sir. That is why the issues were raised, and we have
Yeah,
somehow tried to. I would try to conclude the matter that what are
Yes.
points which were raised. So supposedly there is a common order for 73, 74. The issue starts from the issuance of the notice. Now there can be two scenarios. One, a notice has been issued without issuance of DRC 01 on the portal, which has been commonly done in CGST in the initial years. And second, wherein notice has been issued, but DRC 01 has been issued. So in cases wherein DRC 01 has been issued, there would be definitely a scenario wherein DRC 01 would have been issued separately for 73, 74 as the portal does not allow. And in case wherein DRC 01 has not been issued, then the common show cause notice would be there. And based upon that, an order has been passed. So wherein no DRC 01 was issued, manual notice was issued and manual order has been passed. And subsequently now, since there is an instruction in November 2023, so therefore the department directly issues the DRC 07 and uploads on the portal. So when it uploads on the portal, the question is under which section it would upload, section 73 or 74, because there's a common order. So the portal does not allow issuing a common DRC 07 for 73, 74. There has to be two DRC 07, either in first in 73 for the issues covered under 73 and second in 74 for issues covered under 74. And then for a common order, if there are two DRC 07, how 128A would be applicable? In the view of the house was that for 73 we can apply, for 74 we would have to leave. And for 74, if we leave, the department would reject it, then the appellate route would have to be made applicable. But one thing common, if common notice has been issued, this is one thing which cannot be made part of rectification, and because it's an illegal thing, and once it's an illegal thing, it cannot be rectified through merely under 161 without commencement of fresh proceedings. So this is how the entire scenario can be summarized to the best extent possible. But yes, we would be facing this issue when we would be opting for 128A post the issuance of SPL 01 and 02. Now coming to the next point, where the notice oblique order involves multiple periods ranging from the period for which waiver provided under section 128 is applicable and includes some other tax period for which such waiver is not applicable. Whether the benefit of waiver of interest and penalty or both under section 128A can be availed for the period covered under 128A. If so, what is the tax amount payable for claiming waiver under section 128A? Again, what we were discussing earlier, if the statute does not allow issuance of a common notice and order for 73, 74, statute also does not allow a common order for to be issued for multiple periods. There is a decision of Honorable Madras High Court in case of Titan Industries, wherein similar thing was upheld by the court. But again, the FAQ says, and somewhere down the line upholds common issuance of order for multiple tax periods, and says that supposedly a common order is issued for 1718 to 2122. It says that the entire tax amount has to be paid for all the years before at the time the entire tax amount has to be paid, and then only application can be filed. Once the application is filed and it is decided that the taxpayer is eligible for the waiver, then for 2021 and 2122, the interest and penalty has to be separately paid after issuance of the order for eligibility of the scheme, and it has to be paid as far as I remember within 3 months from the issuance of the order. So this is how the entire this point number 6 goes. So again, we are stuck on that point that common order has been issued. So If we are into appeal, we are challenging something which cannot be rectified and has to be quashed by the appellate authority or by the tribunal or by the court, or in such cases what has been done in Titan Industries, if I correctly remember, the matter could be remanded back for issuance of separate notices. Is there any views from the members?
Sir, in my case, for in 1920, there was one show cause notice, and 2021 there was one show cause notice, but the officer proceeded to issue a combined order for both the years, even though there were two separate show cause notices. Is that allowed? I mean, there is no bar anywhere in the law that they cannot issue such combined, because in the order he has clearly referred SCN, the two SCN, and he has issued a combined order.
Again, ma'am, we come to the same issue which we had discussed earlier, because law envisages for one notice there has to be one order, because there would be one DRC 07. The entire chain goes one notice, one DRC 01, one order, one DRC 07. So if there are two notices, again a common order has been issued, but for that also there has to be two separate DRC 07.
Yeah, but there is no express provision that disallows the officer to do such things, right? There's no anywhere it is not mentioned that you cannot combine two SCN and give a single order.
Now we have to go through rule section 73, 74, read with rule 142. Because if the entire process is correctly followed, there would be one notice and one DRC 01. And for that notice, there would be one order and one DRC 07.
Right.
All these issues are creeping up because what CGST has done, and in my opinion, in Rajasthan, SGST has not done anything of this sort which we are discussing. But every case of CGST is just like this, that they have issued either a common notice and then a common order, or what you have said, two separate notices but a common order, because they were not following the mandate of the portal.
Right.
So again,
Arpit sir, can I come in for a minute,
yes,
please?
yes, sir.
Sir, just wanted to share with all that portal now for some time allows SCN for multiple financial years and also the assessment for multiple financial years. That has been made available online now for some time, but for the earlier periods, of course, it was all being done manually by CGST. It is being done by CGST only. State officers have rarely done, but multi-financial year proceedings online are now available on the portal. Just wanted to share that.
But sir, let's take an example that an order has been passed for say 1819 to 2021. For 1819, it has been passed under section 74. And for rest of the years, supposedly it is passed under section 73. Same issue. Now,
yeah, so I'll just tell you, Arpitji,
yes.
what is how it has been implemented on the portal itself is that the order is considered to be the detailed speaking order. DRC 07 is just a summary of the order, and the entries in the liability register or otherwise, they do not relate to any particular financial year, the way the ledger is constructed and all that. So it is just a summary of the entire speaking order, which may have multiple financial years. So I was just trying to share this in reference to this, that we are taking into consideration. Yeah, I'm aware of that High Court decisions, etc. After Titan, there has been follow-up decision also. But just wanted to share that when we said on the portal, it is not available. So it was not available, but it is now available. I don't know how many actually cases have happened like that, but on the portal, it is available. Just wanted to share that point.
Yes.
The other all implications that, yes, if we go by a combined reading and the High Court rulings, the entire structure, the decisions of the court, if I remember rightly, depend on that for the last date for concluding the proceedings under either of the section is with reference to the annual return. So that means the entire scheme is for each year to be done separately. But just keep this in mind that portal is also now allowing. I don't know the actual positions, the orders which are there for 128A. That would be a different scenario. I don't think, say, 6 months before that, or that all those orders issued a few months earlier, they would be having a joint DRC 07 for multiple financial years. Just wanted to share this one point, that if we say that portal does not allow, yeah, portal was not allowing, but now it is allowing. All other discussions which we are having, they are fine. I don't have any disagreement or any other views or any additions to that. In total agreement with that. Just wanted to share this part.
Thank you, sir. And one another thing which results in common issuance of order for multiple years. The example which I was taking, supposedly order has been issued for 1819 to 2021 for the same issue, but for 1819 they have invoked 74, and for rest of the year they have invoked 73 only. Now supposedly I challenge that 74 has been incorrectly invoked. Now the appellate authority is faced with the issue that he wants to say that 1819, for 1819 the 74 is not applicable, but on merits the demand stays. Now for passing our common order, since part of the year has been part of the order has gone beyond limitation, the challenge comes that how it would be resulting in issuance of the appellate order, and that's why it has been said that assessment proceedings for each of the years are separate, and therefore separate orders should be passed, so that even if the order has to be quashed, it can be quashed for individually for the each year, not in a case wherein multiple years have been issued, but 1 year has to be quashed.
Arpitji, just again adding something more. It may be disturbing the line of thoughts and flow which you are having. Talking about that portal is allowing multiple financial years. So what in fact portal is allowing is single financial year, multiple sections, multiple financial years, multiple sections, single section, multiple financial years. So all these options are now available on the portal for some time. So in future, we may see that orders of the current orders may be under that procedure, the new orders which are coming, but all this is available on the portal if going further, but not for the earlier cases. They have been issued whatever manner they have been issued. Yeah.
I would like to add one thing. Recently, I had a case where, just like Gurpreet sir said, multiple years were bunched in a single show cause notice, and it was also made available in the portal, which the portal permitted. Because I believe that when the proper officer goes and prepares the SCN, there is a question, is it for a single year or a multiple year? Then that's how the DRC1 flows. Anyway, we challenged the notice itself at the notice stage before the Honorable Kerala High Court. And the present bench was of the opinion that as long as every period is within limitation, there is no illegality or prejudice caused by invocation of multiple years into a single proceedings. And since 1718 for us was time barred because a notice was issued on September, the order was that the bunching is permissible, but only thing is the adjudicating authority is not permitted to adjudicate on 1788, and the balance may be adjudicated, and a direction was given. Unlike Titan and Bangalore Turf Club in Karnataka High Court, I don't think that bunching could have be a big difference, since there is not much prejudice cost ultimately to the taxpayer when a single section is used for multiple years within limitation.
Any other views from the members?
Maybe Annapurna madam, I'm sure you are noting this because this is also kind of like FAQ4, an issue that would come up. So let's park it for the discussion with the CBIC for the next settler.
Coming to issue number FAQ number 7. Where the notice / statement / order issued under section 73 involves multiple issues, and one of them is regarding demand of erroneous refund. Whether an application can be filed for waiver of an interest or penalty of both under section 128A. If so, what is the amount payable for claiming waiver under section 128A? So again, what they have clarified is that for erroneous refund, you cannot opt for the waiver scheme. And while opting for the waiver scheme, the entire tax amount, which is for issues other than erroneous refund and for erroneous refund, they have to be paid. And then the option can be filed. And once the waiver benefit is given, then the interest or penalty applicable on the erroneous refund part has to be deposited within a specified period. Now, what I would like to discuss is let me try to share the screen. Section 73(8). Yeah, is section 73(8) visible? Vinuji?
Yes, yes, it is visible.
So 73(8) says where any person chargeable with tax
Mr.
under
Sir.
subsection 1 or subsection 3 pays the said tax along with interest payable under section 50. Within 30 days of the issue of the show cause notice, no penalty shall be payable and all proceedings in respect of the said notice shall be deemed to be concluded. Now, what I would like to highlight in 73(8) is that it says all proceedings in respect of the said notice shall be deemed to be concluded. Because again, this provision shall be deemed to be concluded is there in the in section 128A also. So now let's take an example that there are two issues. One is there are two issues. One is for erroneous refund and second for not for erroneous refund. So now how 73(8) comes into picture? Whether 73(8) says that for each issue there has to be a separate notice. Let's take another example. Because why I'm coming to this, because supposedly a notice has been issued wherein there is challenge to non-payment of tax within a specified period. So section 73 has been invoked for tax and interest, and simultaneously penalty under section 122 has been invoked for section 122 subsection 1 clause 3 for non-payment of tax within 3 months. Now, supposedly, I opt for this waiver scheme, and waiver scheme in one of its FAQ says that penalty under section 122 would also be covered under 128A and would be dropped if tax and interest has been paid.
I didn't get the question. I felt this is clear.
Look, let me.
No, Arpit's point is exactly like in the 73-74 matter. The very issue of notices where multiple paras of multiple issues are there in a single notice was perhaps not intended to in 73 because of the wordings of how 73(8) works. When you are talking about the notice per se being deemed to be concluded, you cannot conclude a notice parawise. So if there are 5 points, there has to be 5 show cause notices under DRC 73 read with and the corresponding DRC 1 for that single para. Like there is a issue of 17.5, there is a question of tax short payment, there is a question of erroneous refund. For effectively deemed the conclusion of all these, one single notice, if it is invoked, there can never be a conclusion of the notice, even if I pay within 30 days for a single para and contest the others. So law intends that there has to be 3 show cause notices. Am I right?
Yes. Because if you go through 128A, now this is 128A. Now 128A says that if the required tax has been paid on or before the date, no interest under section 50 and penalty under this act shall be payable, and all the proceedings in respect of the said notice. So when it is saying that all the proceedings in respect of the said notice, there cannot be a question wherein a notice is covering two issues, and for that you are saying that for the part of the issue you are required to pay, and for the part of the issue you can opt for the amnesty scheme. Either they should have said that no interest under section 50 and penalty under this act shall be payable, and all the proceedings in respect of that para or that issue arising in the notice shall be deemed to be concluded.
Sir, can it not be looked in this way that the law allows all the multiple issues to be raised in one single show cause notice? But to avoid litigation, this is just a compromise scheme, be it 73(8) or 128A, which is being offered. It is a compromise scheme that if you want to reduce litigation, you pay the entire thing and let all the proceedings deemed to be concluded. But in case if you want to dispute it partially, then this scheme, this benefit which is offered will not be available, and you'll have to follow the regular route.
No, if that is the case,
But Praveen, 73(8) allows me to close paras if I pay that para within 30 days with interest. It is, even though it talks about notice, as per the present prevailing practices, both in CGST as well as SGST.
Yeah, but section per se does not allow that.
That is why we are of the opinion that the section always talked about issue-wise notices.
No, then if that is the case, sir, if 17.5 for block credit, if there are three different disputes which is being blocked, say one is for this immovable property, another one is for motor car, then to what extent there'll be separate notices for each of the issues within the ineligible input tax credit?
I would say that it will be in 5 major buckets. One is for erroneous, one is for short payment, one is for non-payment, one is for ITC availed, and one is for ITC utilized. Just like in 73(1).
Then that issue will still remain, no, sir. Like if you want to dispute one of the ineligible credit, if there are 3 different issues under 3 different subclasses,
then for that bucket, your interpretation that even if there are multiple subspecies in single head of input tax credit, for 73(8), you need to close all and not one.
Praveenji, I would like to come to FAQ 12 because it is connected with that. FAQ 12 said whether section 128A will cover waiver of penalties. I'm not going for late fees and redemption, that would be separate. It is clarified that any penalty, including penalties under section 73, section 122, 125, demanded under demand notice issued under section 70 is covered under the waiver provided under section 128A. So the question comes that if the notice has been issued under section 73, why they are saying that penalty under section 122 and 125 would also be concluded? Because the intent is, yes.
Yeah, sir, in this case, let's suppose the notice was issued under section 73, sir. And for one of the issues where there's no specific penalty which is being provided, they've also invoked section 125, a general penalty. Say, for example, for a mismatch between some GSTR 1 and e-way bill. So their e-way bills were not generated. I'm just saying whether it is legally possible or not is a different thing, sir. Where the tax was not being proposed, but only penalty under section 125 was being proposed for not generating e-way bills. So now this notice would cover taxes for other matters and 125 penalty for this matter. And if I'm paying the tax per se for the other matters, is 125 penalty also may be waived.
So again, then the wording under section 128 is all the proceedings in respect of the notice shall be concluded. So can I say that if I've opted for one issue under section 73, even if a penalty which is not connected with that provision would be dropped?
Possibly, yes, sir.
again the question comes, what Unikrishnan ji and I was trying to say, that the law always intended that for one issue there has to be one notice, and there cannot be bunching of two separate issues, because two separate issues are completely different. And if there is a one issue and one notice, therefore all the penalties and all the consequential interest for that issue would be dropped. But if there are multiple issues, then we cannot say that if I opted for one issue, the second issue, since it only involves 125, would also be dropped. Let's take an example that my case was selected in audit and there were only two issues. First issue, I incorrectly charged the tax of 12%, whereas I should have charged 18%. And simultaneously, the officer also levied a penalty under section 125, incorrect filing of returns. Now, supposedly I go for 128A under section 73. What happens to that penalty under section 125? Because this is for entirely unconnected matter. And secondly, section 73 for delayed payment of tax, along with 122(1) clause 3 for non-payment of tax within 90 days. Because that specific wording of section 128A, all proceedings in respect of the said notice shall be deemed to be concluded, would have a larger role to play whenever the litigations would come, that whether at all it was a connected issue or not a connected issue.
Agreed, sir.
No, first of all, in a notice or a statement under 73, how can they propose a 125 penalty? 73 has no machinery to invoke a general penalty.
It is otherwise, no? 73 has no power to raise penalty. Only 74 has.
Fine. Agreed.
No,
even that, even the reference to penalty under 73 in the circular seems to be on a presumption that it has independent powers to penalize.
Correct.
That itself needs to be addressed.
No, the powers would have been borrowed under 122, 125, but the demand is created under 73.
But then the circular says any penalty under 122, 73, 122. It looks as if both are separate and independent of one another.
Agreed.
So Venuji, it's 10 o'clock. We will keep it as it is for next to be discussed in the next session.
Correct.
And
we will not hurry this.
Yes.
We will not hurry this because this is going to be crucial in the coming months.
Yes. The question is, what is the scope of the terminology? All proceedings in respect of the notice shall be deemed to be concluded.
Mark it. I'll mark it. So we will continue from FAQ 12.
No, FAQ 7. I jumped to FAQ 12. FAQ was FAQ 7.
Correct.
6, 7.
Yeah.
It was 7.
Done. Yes. Okay. So we will pause the session now and we will again resume back in the coming week. Anyone has any points, any doubts, anything you want to ask before we conclude?
I have a doubt regarding last week's SMS on point 4.
That is point 4 is a multiple views answer. We will be concluding it at the end.
Okay.
Yeah. Okay. Then thank you everyone for joining. And thank you, Arpit Bhai, for filling in, and Arup was there. So it would be a feast for us. Next week, you and Arup will jointly conclude 128A.
No. We will only discuss.
Yes.
All proceedings for this discussion will not be concluded.
We will also violate. Why only CBIC circulars?
Yeah.
Okay. Great.
Okay.
Thank you all. Thank you. And good day.
Good day.